Good afternoon. Lee asked me to come talk about various topics dealing with what's going on in the state government today, but he only gave me 25 minutes. I think that's a subtle hint there, but I'll try to be. And those of you that have heard me in the past know that I find it very difficult once you give me this forum to keep my mouth shut. But I see Lee in the back. I'm sure he'll give me the hook this time. But if we have time, I'll be glad to address any questions you may have, and then afterwards I'm going to hang around for a little while, lose $100 and then head home. First topic that Lee wanted me to talk about is the emergence of the fire districts here in Alabama. I don't know whether you guys are familiar with this or not, but I was not until December of 2017. I got a call from Jean Ray Taylor in Tuscaloosa. Most of you probably know. And Mr. Taylor is a prominent member of ours, and anything he says quickly gets my attention. But he brought up that the land that he owned in Jefferson County was being assessed for being a member of the fire district at the rate now of $8 an acre per year. I mean, think about that. His ad valorem taxes are probably $2.50, $3 an acre, and then to kind of put it in perspective, and those of you that are professional foresters or members of the Forestry Commission, please bear with me as I try to simplify this. But in Alabama, we pay a severance tax on timber that's cut, and the proceeds of that severance tax goes to the Alabama Forestry Commission for the purposes of providing forest protection in the state. Principal amongst that is forest fire protection. So the Forestry Commission is the people that, from our standpoint, that are vested with the overall responsibility of fire protection. If you take an average acre of commercially managed property, forest land, you get about, on average, about 10 tons per acre per year. So if the severance tax is a dime per ton, then we're paying, in essence, about $1 per acre per year to the Forestry Commission, who are the professionals and who have the equipment and have the training to provide forest fire protection. So compare that dollar to $8, and you can kind of see where the stress begins. Well, where did the ability to form a fire district come from? And let's distinguish a fire district from a volunteer fire department. A fire district is a statutorily created entity where at some point in time the people of that area got together and passed a referendum and delineated a geographic area and agreed to everybody had to participate in that within that area. Well, in Jefferson County, the particular fire district that we were dealing with initially was Birmingport. We've since learned that there was another one named Concord, and they're the two main ones that have decided to assess fees to vacant timberland. There we found out at least 15 other fire districts in Jefferson County, and as we began doing the research, came to find out that there are fire districts all over the state. Well, early on, we thought it was local legislation that created this authority for Jefferson County, and indeed, Concord and Birmingport did get formed due to that legislation that was passed in 1966. Well, the original legislation said if you're going to raise your rates, you got to go back to a referendum of the people. The fire district administrative folks found that to be cumbersome, and then 5 years later, they came back and changed the local law to allow the board of directors to assess fire damage. So, and if somebody didn't like it, their only recourse was to get 30% of the electors within that district to sign a petition that had to be delivered to the probate judge within 30 days. And then the probate judge could call a referendum to question the raise in fees. Well, that's a pretty cumbersome thing to do, 30-day period. So since that time, I think in 1990, Concord Fire District was the first to enact dues on vacant timberland at $1 per acre. And then over time, by 2011, it had climbed to $8.33 an acre. The principal landowner within the Concord area at that time was United States Steel. And the local people wanted to challenge the increase in fire dues, but they took it up the corporate ladder, and the U.S. Steel said, you know what, let's just categorize it as doing our corporate duty and pay it. So there was no objection to it. But fast forward to about 3 years ago, U.S. Steel sold this property to a company out of Mississippi called Forestry. And they had no idea what they were getting into, And when they got their first assessment, they went nuts, obviously. And so they called us in December 2017. Our first initiative was to introduce a bill that would amend that local act in Jefferson County to just exclude vacant timberland from fire districts. And obviously it was an election year. No disrespect to our elected official here in the room, but they tend to listen to their constituents. And the constituents were telling them that they didn't want to exclude timberland. They wanted to assess it as high as possible so that they could use it to discount their rates that they were paying for their houses. So the elected officials that represented these areas essentially just killed our legislation last year. During the course of that, I was doing more research and was very troubled to find out that in 1989, the legislature passed a bill that provided the capability of forming fire districts all over the state. And so, and to my knowledge, I believe there's some in Baldwin County, some in Mobile County. I know the legislature just created one, or created the opportunity for the people to vote on one in around Dothan. I think Walker County has some, Tuscaloosa County. So, I think they're out there, but they certainly have the statutory ability to form. Those that are out there, I can assure you, are watching what's going on in Jefferson County, and if these guys get away with it up there, you know what's going to come down the road soon too. So we have been in about a 14-month negotiations with Concord and Burlingport to try to come up with something that they can live with and that our folks can live with. And unfortunately, we just haven't gotten to where they're reasonable. So we introduced legislation this session in the Senate. Senator Albritton from this area, he's the senator for this area, is carrying our bill. It's Senate Bill 282. It was introduced about 2 weeks ago. It went through the Agriculture and Forestry Committee in the Senate and is now poised for consideration on the floor of the Senate. If it were to prevail there, we still have to go down to the House of Representatives and try to move it through there. So The bill is about as simple as you can get. It's a 2-page bill, and I'll read you what it says. Section 1A, a local fire district shall not be authorized to assess any type of fees or dues upon forest land that is treated as timberland for ad valorem tax purposes. And B is the authority and responsibility for the control and coordination of fire prevention, fire protection, and firefighting services on land treated as timberland for ad valorem tax purposes shall be under the jurisdiction of the Alabama Forestry Commission. So it's very simple, and it's simple to understand. Unfortunately, it seems like a no-brainer to be able to pass, but as Representative Pringle, potentially future Congressman Pringle, will tell you, there's no telling what might emerge during the legislative process. So that's kind of where we are with fire districts. We're going to keep fighting and just keep an eye on it and see how we're doing. Are there any questions about that? Yes, sir.
Where did you see this apply specifically for the state of Alabama? Or?
The question is, where did it come up specifically for the first time, to our knowledge? It's Jefferson County, western Jefferson County. Yes, sir.
Is any abuse of the money by the fire districts? I mean, are there 3 or 4 individuals that are getting a lot of that money?
We have, I'm trying to be polite here. I think I'm being recorded. The 2 fire districts in question have not filed a Form 990 since early mid-2000s. So we don't know. They're not being audited. If we don't prevail on our legislation, then that's the next step, is we're going to start trying to force them into an audit procedure. The state has a audit function within the legislature called, I can't even think of the name of it now.
Examiner of Public Accounts.
Thank you, Examiner of Public Accounts. And so we'll, that's the next step. We'd like to just get out of their business and move on, but if we don't pass it, then you can rest assured we will be in their business. Yes, sir.
The fire district, what do they do with that money, and do they have assets? What's the purpose of the fire district?
The question is, what do they do with this money? The Concord Fire District, I mean, they're a real fire department. I'm not suggesting they're not. They've got probably 3 locations, 6 to 8 vehicles. They've got full-time staff. So to my knowledge, they're fully capable of doing what they're supposed to be doing. What I do know is that they don't have the equipment or the training or expertise to do fire protection on timberland. Anything else before we move on? All right. The second topic I wanted to discuss with you, again, gets into the property rights issue. I assume everybody in here is a timberland owner, or you wouldn't be at the Alabama Forest Owner Association meeting. How many of you have easements across your property? How many of you are versed in what that easement says? So you may have an electricity line through your property. I'll talk about that a little bit more in a second. But what you might have as well is a railroad easement. And I don't know if you're familiar with my favorite topic and my friends, the Nettles from Groveville, is the Rails Trails program. And we're actually at the southern terminus of a rail line that is up for abandonment now, that goes from Atmore up to Tunnel Springs, Alabama, which is just north of Monroeville. It's about a 47-mile track. Formerly owned by the Alabama Railroad Company, or currently owned by the Alabama Railroad Company, and they want to abandon it. Well, it used to be prior to the 1983, if a railroad ceased to use your easement as a railroad, then they would go through a proceeding called an abandonment proceeding, and once the final resolution of that was determined, then your easement would revert back to you. If you read the terms of that easement, it probably says that they have the right to put in a railroad and to operate a railroad. Railroads over the years have acquired easements in many different, or have acquired their corridor in many different ways. Sometimes it's just an outright purchase from you, and sometimes it was a condemnation, but most of the times it was through an easement. And if that easement extinguished, then their rights extinguished and it reverted back to you. Unfortunately, in 1983, Congress, in their wisdom, decided that the fact that railroad corridors were key to the ongoing betterment of the country, wanted to create this concept of rail banking, where a railroad could abandon in principle, its right-of-way, but retain the right to come back if a need for it emerged. I don't know what the original need was for this 47 miles from Atmore to Monroe, but obviously it's disappeared, and obviously they haven't used it for some time. But there could be, an automotive plant or something come in, and they may need that right away again. So in order to grant the railroads the opportunity to bank the corridor, they created this public use concept that if they banked it, they could then enter into an agreement with an instrumentality of the state or a private organization to use it for a public use. The main use publicly has been bike trails. And so there's a huge effort nationally to create an infrastructure of biking trails, and these railroad corridors are good for that. So here we are. Keep in mind now that as long as it's being used for that public use, of which you have no control over as a landowner, the abandonment never becomes complete, and the reversion never happens back to you. So what happens is that during the abandonment proceeding, an organization asks for permission to negotiate with the railroad for this public use. They have 180 days to negotiate, and then they can ask for 180-day extensions, and there's no limit to the number of extensions. Some of these negotiations have been going on for as long as 12 years without any movement towards actually funding or building the bike trail. So there's a couple of corridors in Alabama. One was from Monroeville up to Beatrice, about a 7-mile project that I'll talk about in a second. There's another one that originates in Andalusia, I believe, and comes up through several counties. And then there's another one referred to as the Wiregrass Trail. And they have to buy the corridor from the railroad, so they got to come up with money. And then they got to turn it into a bike trail, which means taking out rails and bridges and doing a lot of work, which takes money, obviously. So we're opposed to them because we want to see the landowner have its reversionary interest restored. And so we've been working against them. The 7-mile track from Monroeville, from Tunnel Springs up to Beatrice, was being championed by the Monroe County Commission. And they had gotten contributions to buy the corridor, and we're in the early stages of actually building the bike trail. Well, 3 minutes. All right. So you should have given me 3 hours. So long story short, we were opposing that, and it went through several of our members' lands, including the governor of the state of Alabama. And we found one tract that the railroad, when they quit claimed the interest to the county, they really didn't have the right to quit claim that interest. And so the Nettles and others brought a lawsuit in Monroe County. The judge ruled with us, and the county commission appealed it and went all the way up to Alabama Supreme Court. We got a ruling yesterday that affirmed the lower court. So that's a big step, a big important step. It doesn't end it. And we've got to come up with a solution. If I had another hour, we'll talk about it. Let me quickly, in 1 minute 45 seconds, talk about a bill that's pending in the Alabama Legislature, House Bill 400, which gives the electric utilities the authority to expand their easements, which you have, to include broadband services. And essentially, nobody here argues that we need to increase broadband infrastructure in the state, and nobody here argues that using existing easements or existing corridors is probably the smart way to go about it. Problem is that we're now giving, in this legislation, condemnation authority to the power company to condemn property for purposes other than building electric infrastructure. Second problem is that there's no compensation to the landowner other than the value differential between the property before they installed the broadband and the property after. Well, it's already a corridor. You're not getting any timberland. You already, in the original easement, you paid for the property, so you're not going to get anything for letting the power companies come in and put in this new service. And by golly, I can assure you they're going to get paid for this additional service, so the landowner doesn't get anything. Third problem with the bill is that you've got, from the date of the act passing or the date of them installing the broadband, you only have 2 years from that date to bring a civil action. Well, if you're an absentee landowner, you don't know when they install the broadband. So we've asked them to make them provide that notice in writing to you. Well, the 3 things that we've asked them to do, they said no to all 3. Alabama Power Company is not called the fourth branch of government for idle purposes. You can talk to Representative Pringle about this later, but I don't see us being able to do much to stop this train coming. So, I think my time is up. I have 1 minute. I haven't gotten to stop one yet. I had hoped to talk about, this is interesting because I was about to talk about fiscal responsibility, and that stop sign you just showed me is the same stop sign we get when we talk to legislators. So, on that note, I will be around. I'll be glad to answer any questions anybody may have. If there's somebody who's got a question right now.